First, I want to say thank you for having us here. I find it invigorating to be at a law school and a place of higher education. And I really appreciate what the Vice Chancellor said this morning about, and let me build upon this. When we were coming in our van this morning, we were noticing some of these gems of knowledge in the gardens, basically, where you'd walk past something and you'd see a saying that makes a lot of sense and resonates. And what the Vice Chancellor said this morning was that in the race to excellence, there is no finish line. And so it's great to be part of that. And we're talking today a lot about the future of e-discovery and where it may go. And I want to make a similar remark that there is no end of the future for e-discovery. So I'd say it's more the next chapter. So today what I'm going to be speaking on is AI and associated clinical data privacy considerations, an illustration of e-discovery issues. So James, a colleague of his, and I co-authored this paper talking about how AI will be and will continue to be used in the application of clinical data, clinical studies to develop new therapies by pharmaceutical companies and biologics. And we're going to take a look at how those considerations that come up in that application really bring up a lot of issues here relevant from the e-discovery perspective. So for those of you who may not have or have only pretended to have downloaded and read the paper, I'll give the briefest overview of that. And then some of the issues that I want to cover that I think will come up and hopefully resonate from the e-discovery side is mitigating conflicts between legitimate and contradictory interests, different levels of privacy interests depending on the data subject or type, cross-border transfers, which I think is something that came up earlier today, talking about the different regulatory regimes between a privacy as a fundamental human right and a discovery and truth in disputes as a fundamental right. Consent, transparency, what those subjects mean in this context. Subject access requests, we talked about that briefly. We haven't really covered the right to erasure, right to rectification. And then redaction, anonymization, and pseudonymization before we get to any questions. Although I will say this, feel free to jump in if you have a question in the interim. So first, a quick overview of the paper if you didn't get a chance to download and take a look at it. So it looks like at a Swiss corporation that conducts a clinical trial and has Swiss data of health information of patients. It also has licensed out with what we called in the paper partner data to get additional data and used a combination of those data points in order to further its study and analyze a potential NDA new drug application. And so what we looked at is considerations of how that data is handled. If it's anonymized, if it's based and collected in Switzerland, then it's subject to certain Swiss regulations. And that would require additional steps, additional kinds of consent. You also have limitations on portability and erasure given scientific and research purposes. Obviously, if you're part of a study and that study is being used and applied for clinical trial purposes, you can't then opt out and essentially taint the entire study at that point. And then the implication for record-keeping requirements of decisions made and actions taken. So now we'll do a little bit of a rapid fire through issues that this raises in light of e-discovery concerns as well. So first is mitigating conflicts between legitimate yet contradictory interests, which is a bit of a handful to spill out. But earlier today, when we had the minister here, he was talking about, think about e-discovery from a public policy perspective. And that's really important here. Jason talked about, what do you want? That was one of the questions. What should you be taking away and saying, what's good about e-discovery? What can we learn? What's the good aspects of it and what's the bad? So let me walk through some of the contradictory interests that you have in the clinical data. You want as much potentially relevant information as possible to shed light on potential treatments and differences which could impact the efficacy and or side effects. In other words, you can save lives. Big deal. Heavy thumb on that side of the scale, right? Versus, I want to protect my private sensitive health data. I want to limit its use. I want control over its distribution, access, and attribution. I don't want, and I'm not comfortable with it being used to discriminate against me. That's a pretty big side on that V, pretty big thumb as well. Now, similarly, this brings up the e-discovery tensions. We want relevant and proportional information to decide the disputes on the merits. Truth, justice. These words are literally carved into granite for good reason. Heavy thumb on that side of the scale. The other side of the V, avoiding expensive fishing expeditions and producing unnecessary private information. Again, getting to what the gentleman said earlier today, the fundamental human right of data protection. So both here we've got the AI on associated clinic data, bringing up these issues, as well as e-discovery as well. So different levels of privacy interests. I'm going to pick up a lot on the GDPR because I don't pretend to be an expert on Indian law, let alone pending legislation that is not yet passed. So I'll use that, and then we can extrapolate for application based on its similarities. But depending on what the data is, you have different requirements of how it's handled. So under the GDPR, personal data definition is any information that could be used to indirectly identify a natural person. So this always gets my American colleagues up in an uproar because when they're thinking about a big document, we've been talking about email all day long. What's at the bottom of every email I've received from Jason Barron? Jason R. Barron, blah, 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 drinker bitter, blah, blah, blah. What is that? Right? But if I were to go to my American colleagues and say, I need to redact every single signature block on every single email, the service providers would be buying beach homes and Lamborghinis. But I don't think that would go well in the e-discovery side in America. So that's one aspect. I mean, in the U.S. we do have it, but it's not on the same level, and it's really focused on certain financial and health information. And then you have special categories of information too that are more sensitive that you would assume have a higher requirement. And so the point I'm trying to make here, in both the clinical data context as well as in the e-discovery context, not only are you facing different nation-by-nation regulations that you have to keep track of, but within each data set, you have to think about what kinds of data you have in that data set, because each of those could be regulated differently, even intra-nation, let alone across a handful of nations. Next up, cross-border transfers. So this is, a little bit of my specialty, but noting the time, I'll try not to, take too much with it. Otherwise, we'll be camped out here and be here on a Sunday. But the U.S. regime has very limited recognition of borders at all for cross-border discovery. So caravan coming from South America, let's get a border wall up. Discovery incoming, no wall whatsoever. And then if you look at our actual rules support this. So Federal Rules of Civil Procedure, parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case. Nowhere in there does it say in the United States of America. Nowhere in there does it say by an American citizen, by a resident of America. We also have the possession, custody, or control standard. So if I am an American in America, but I have foreign data, or I have a corporate relationship, or the practical ability to obtain that data, I may be required to turn it over as well. So we do have a limited border recognition in light of data protection and blocking statutes regimes under the Supreme Court case of Aerospatiale. And one of the factors, well, it basically sets out a 5-factor test. And there was a great law review article about this case that basically predicted and proved with a statistical analysis that US courts would put the thumb on each of the 5 factors heavily, heavily, heavily in favor of producing that non-US data in US courts. And that continues to be the case to this day, with one glaring exception, and the reason why it's such a big deal in this one case, it's the Salt River case, is because it is such an exception, because it was a very thoughtful analysis and consideration of the foreign data subjects' interests. And then within that, the EU has adequacy determinations of when you can transfer data outside of the EU. There are a limited number of what's called whitelisted countries. And then you have other means of transfer, including standard contractual clauses, binding corporate resolutions, and others. But these only get you halfway there. So standard contractual clauses says basically for related corporations, you know, corporation in Switzerland can give it to corporation in the US and not be bound. But then that presents a little bit of a problem, because if the corporation in the US then gets that data in the US, it is where? Okay, I know it was after lunch, but that wasn't that difficult a question. It's in the US, right? Correct, exactly. Now, imagine me. I'm in a courtroom in the US. I have data on my laptop right over there due to a standard contractual clause. Judge says, Taylor, Mr. Hoffman, produce that data in this case right now. I say, no, Your Honor, you see, I can't, because then that would constitute a cross-border data transfer. What are you talking about? It's literally in the courthouse. So, limitation on standard contractual clauses and how much that can get you in the e-discovery context. In normal day-to-day business relationships, it's highly, highly beneficial, but it creates that wrinkle there. So GDPR has a bit of a get-out-of-jail-free card for the e-discovery context, and that's Article 49E, derogation for the establishment, exercise, or defense of a legal claim. But before folks think that this is a 110% get-out-of-jail-free card, the DPAs, the data protection authorities in the EU, have made it clear that it's got to be necessary. Necessary. What does that mean? Now, we went back to the Federal Rules of Civil Procedure on a previous slide. Is it everything under there? Everything that's relevant and proportional? Is it what's going to be used at trial? Is it what's going to be used as an exhibit in a deposition? We don't know. So there's still some levels of uncertainty there. And it must be occasional. It must be non-repetitive. Well, wait a minute. Is there a tension there? Because one of our data protection safeguards was phased discovery. You give up a little discovery. You give up these 4 custodians. You see where that gets you. And then do you have to go to another 4 that you identify rather than giving up the initial 8 all at once? And is that then repetitive and non-occasional? So there are some tensions in here as well. And then one thing I'll note here is that remote access is too cute, and they know it. So that counts as a data transfer as well. So consent, this came up in the clinical data trial, obviously, and so a lot of folks try to use this as a derogation to get data out as well, but I'll just raise a couple points. One, how can consent be freely given in the employment context? So if legal comes to you, we talked a little bit earlier about humans and dealing with custodians. So you go to employee A and say, you know what, can we get your consent to transfer this data out of Germany or what have you? And they were like, well, you know, I just don't feel comfortable with that. Okay, well, let's have your manager explain to you right around bonus time how important this litigation is. Let's have that conversation then. That's probably not freely given. So that's an issue. The other issue is the right to withdraw. So I'm back in the courtroom. I got consent. I then give it to the opposing counsel. They have submitted it to the court as exhibits to motions. So it's now with the court. It's with our service providers. It's with our outside law firm. It's with their outside law firm. And then it's with us in the U.S. Now they have withdrawn their consent. There is no way, we have a phrase in the U.S., you can't put the toothpaste back in the tube. There is no way that you can, I guess maybe a better one to mix metaphors is unring the bell there. So another problem here is if you try to rely on consent, and you say, do you consent for this? And then they say no, and then let's see if this one, you say April Fools, we're relying on a different derogation. You actually have a less happy custodian. So better not to try with consent at all, which is in contrast to the requirements in the clinical data aspect, but I wanted to raise the point as well. See, I loved cross-border so much I accidentally went back to it. So transparency. So under the GDPR, transparency must be lawful, fair, and processing must be lawful, fair, and transparent. We talked about legal hold notices. This is a great way to be transparent. How transparent must you be, and at which increment? So we're preserving your data. There we go, we'll let you know. Okay, it's going to our in-house counsel to preserve and call. Is that a separate notice? How many times do you have to keep letting folks know about it, and to what extent? Creates issues for folks. Another knotty problem is, so let's say we take James's mailbox and we are transparent with James. He's on hold. He says, yes, I'll comply. I won't destroy anything, blah, blah, blah. But we pull him on hold, and he has hundreds and hundreds of other people who aren't technically custodians, but we're pulling their data in as well. How do we perform that transparency? Creates some issues. So it's almost, in the clinical sense, you know, you're not a part of the trial, but somehow your health data gets included in it. Stealth concerns. So you, getting back to the German emissions cheating device, you'll let all the engineers who are guilty of all of this fraud, hey, you must preserve your data. All right, you're facing jail time. Some American lawyer just told you to preserve your data. You want to go to Disneyland in the future. What are you going to do? That's not a good way to preserve data. That's the answer. So how do you comport your transparency requirements in a stealth investigation and government investigations? So subject access request, right to erasure, and right to rectification. You know, we talked about in the clinical data context, this was an exception to the right to erasure. Here, subject access request, you can basically say to a company, give me all of your data about me. This is a good boon to the e-discovery professionals of the world, but what's more important is it's a good heads up to company. This person is about to sue you. Right? They're not just a squeaky wheel. Well, maybe they'll be a squeaky wheel in litigation. Right to erasure and right to rectification. Any tension with our preservation obligations there? Yes, is the answer to that. The practical application answer to that is, okay, well, for the life of the matter, you will rectify one, you'll have version A, and version B, preservation copy, and then at the end of the life of the matter, you get rid of the unrectified one. And then for the right to erasure, similarly, except there's no need to do the two versions. Okay, redaction, anonymization, and pseudonymization. So first, how good is this for e-discovery? What opposing party, government regulator, or court is going to agree to me saying, all right, well, we won't redact all the signature blocks, but we'll change every John to James and every Jason to Taylor and every Mary to Sue, and we'll have a key somewhere in the EU. that's going to be a big fight to have happen. A big fight to have happen and a big expense to get it right, and a timely one at that. Now, so you've got some real problems on the e-discovery side, but how good is it actually at doing what it purports to do? There was a study over 10 years ago that using date of birth, a zip code, which is basically the local area, and gender. This was in 2007. This was a long, I mean, for this sort of data analysis a long time ago. They were able to identify 87% of Americans based on those 3 data points. So, you know, you think about even an org chart and going outside. So we know, let's say it's John Doe and Jane Smith. Well, okay, you go to LinkedIn, you go to a couple other outside data sources, and I don't need AI and an algorithm necessarily to start figuring this out. I need an intern, right? So you can unmask it. I have talked to some outside counsel who basically include this as part of their protective order, saying you agree not to go outside to do that. So there are some ways around it. All right, so I think I went over my time, and yes, but it looks like James has a question. It was basically, you know, in the clinical data or the clinical trial data set, you knew this sort of data is all health information, so it all has a higher standard of dealing with it. Now, what happens in an e-discovery matter where, for whatever purposes, maybe James didn't mention this, maybe it's a product's liability in a pharmaceutical case. Could be the same clinical trial that just didn't do a good job, and 10 years later, here we are. You essentially at that point know that, okay, this is going to be dealing with a lot of that sort of data. So then, what can we get out? So, what can we negotiate with the other side to exclude at this point? So you might be able to say, okay, plaintiff's counsel, you already have your 6 to 12 named plaintiffs. At this point, we'll keep those names in, we'll keep that information in, and the rest of the names will come out. You'll get the underlying data, and then we can associate it with names as we need to go forward from there. But in a way, just knowing that you have all that information and dealing with it up front is helpful, even if it's a costly venture to protect it. Any? All right. Well.
It was wonderful. I mean, you covered the GDPR also. And I just want to ask you, as GDPR is active now, so is it impacting the e-discovery practice in London or the e-discovery where the global projects are initiated?
So one of my statements about the GDPR is, what are the potential penalties under the GDPR? And people are like, well, it's up to 4% of global turnover, or 20 million euros, which is greater. And I like to correct people, and I say, no, the penalties are the greatest PR ever. And so, yes, it has greatly impacted practice. But what I think that you'll see, because it built on the core concepts of the 1995 directive. So for companies and entities that had robust safeguards in place prior to the GDPR, there was not a fundamental change. So did you have to do your data impact assessments? Yes. Did you have to maybe change some of your documentation practices? Yes. But was it a night and day shift? I really don't think so. And if it was, you needed that, or that entity needed that wake-up call to change what was not a good practice. And in talking to some of the DPAs, they made it clear that their first enforcement actions are going to be going against those companies who would have already gotten in trouble under the directive.
Yeah, hi, my name is Alok Kumar. I'm from THS Law Firm. The question which I have is regarding the right to erasure. which is same as right to be forgotten, which is mostly used in Europe. And in Indian courts, we have a tendency to use more of a European language and words rather than the American one. So right to be forgotten has been borrowed from the European concept, which is same as right to erasure. And this has started recently because there were a couple of cases in Delhi High Court where people did file a case against Google, etc., because there was some precedent and there were some criminal records, and every time somebody will search for the name, it will be one of the top 10 criminals of India or something like that. So my question is basically is that when you have exercised the right of erasure, either voluntarily or through the direction of the court, which has happened in India, after that, when there's a question of disclosure, how are you going to protect that, or what rights do you have from the, insofar as the person who is holding the data is concerned? That's the question. So balancing between right to erasure and disclosure.
Right, and so I'll actually make a distinction, and perhaps this is too fine of a nuance, between the right to be forgotten and the right to erasure. So when I speak of the right to erasure, I'm talking about a company having data about a subject, and then that company having to delete that data. When I think of the right to be forgotten, what I'm thinking is search engine optimization and where it shows up in Google's hit. So Google just essentially disassociates it. And that's I view them as distinct concepts. So then I'll answer from the company in the right to erasure context and how that meets with our preservation needs. So day one, let's say I have data about you. Day two, you invoke your right to erasure. Day three, I analyze and implement your right to erasure and erase data related to you. Day four, I get a new litigation hold in place, and it would have covered your data. But the thing about U.S. discovery and the preservation obligation is it attaches at the reasonable anticipation of litigation. So if I reasonably anticipated that litigation prior to or contemporaneously with your request, then I basically put it on hold, and for the life of the matter, your request does not go through. At the end of the matter, it does if it's otherwise appropriate. But I don't get burned if on day three, I appropriately implemented your right to erasure request, and on day four, preservation obligation came to being. Pardon me? Right. I mean, so there was going to be, it's not going to be fully objective because, the reasonable anticipation of litigation is not a fully objective inquiry. But big picture, if you document your decisions of why you did it and it's reasonable, not the standard of perfection that we talked about, and Jason's standing up, this means shut up, Taylor. Then you'll be in the clear. But with that, I will thank you all very much for indulging me.
Please give a round of applause.